from the larger group and had pushed through cutting and then smashing down the Constantine wire and pushing down the barriers. When the National Guard troops had attempted to hold the line, a group of the front part of that large group attacked the National Guardsmen, causing them injuries, and then continued to push forward up to Gate 36. They were eventually taken into custody by a combination of Border Patrol, National Guardsmen, and DPS troopers. The DPS troopers and National Guardsmen were able to regain control of the scene, and the 425 people were eventually taken into custody. It was determined that a little less than that, about 326, would face, the Department of Public Safety wanted to prosecute or put charges on about 326 people. They eventually were able to make the arrest on about 221 people. The remaining individuals that they were not able to make the arrest on, some of them had been shipped out by Border Patrol to Houston. They just simply didn't have the facilities here. Border Patrol didn't to maintain all of those people. Some had already been released in the deportation process. DPS eventually made the arrest on a little over 200 people. The sheriff had, El Paso County Sheriff Richard Walls had made arrangements in the jail to accommodate up to 300 people. That wasn't necessary, as there were only about 200 people that had been arrested. Department of Public Safety made those arrests, put those people into jail. Working with our office, they had targeted 9 people that they were able to identify as the instigators, as people who did the wire cutting and who did the actual assault on the National Guardsmen. These are the people that were kind of in the front of the group that was pushing through. Those people have been identified, have been charged with felony riot and felony charges of assault on a public servant and felony charges for the combined mischief that was charged, the combined damages and charges. Those seven of the 9 people, 2 were released by Border Patrol, and the Department of Public Safety are still looking for those 2. The 7 others who were caught and were booked in the county jail have already gone before a grand jury and have been indicted. Those 7 remain in the county jail under felony indictment. Those 7 did not go before a jail magistrate for a bond reduction hearing, because once they are indicted, they go before a felony court, and the felony court does not refer to the jail magistrate for bond reduction hearings. So those 7 are proceeding in our court system under felony charges as any other individual under felony charges would proceed. We anticipate normal felony proceedings on those 7 people. The DPS proceeded with the arrest of another 100 and some odd people, 200 people, for misdemeanor riot, which is a Class B charge. The essential elements of that are that if you are knowingly participating in a group, and then that group then commits an offense, like the criminal mischief of smashing down or tearing up the Constantine wire or the fencing, then you are guilty of the actions of that group. Once you see that the group is proceeding and it is reasonably anticipated that that group is going to commit an offense, it is beholden upon you to withdraw, to exit the group. If you do not exit the group, then you are guilty for the offenses that that group participates in. So, as mentioned, the individuals in that group of 400 that participated and pushed through the wire and continued in a very cohesive group are all charged with riot, a Class B misdemeanor. Those are the individuals who were booked into the county jail starting on Friday. Some of them lasted past midnight on Friday, so technically their booking time was on Saturday. Those are the individuals who were, under our system here in El Paso, were entitled to a 48-hour bond reduction hearing. That happened on Friday. Being booked on Friday, they were entitled to a bond reduction hearing on Sunday. Judge Acosta texted me on Friday, letting me know that there was a very large number of people being booked on Friday, and that would result in a very large hearing on Sunday. Under the law, we, either side, the state or the defense, are entitled to ask for a 48-hour, if we receive notice of a hearing in less than 2 days' notice, we are allowed 3 days' notice on any hearing in court. We can ask for a reset, that we can ask for a continuance. I informed the judge that because it was Easter Sunday, that these hearings would be taking place on Easter Sunday, that because probable cause had already been found to hold all of these people, because we had a warrant. A warrant had been signed off, which was probable cause to jail all of the 200 some odd people, and because all of them had a bond that was set with the warrant being issued. And in our opinion, the state's opinion, those bonds were reasonable because they had a bond set and because they had already had probable cause found to detain them, that it was our opinion that because we didn't need to add the staffing, we didn't need to detain, continue to have all of the extra resources poured in on Easter Sunday, that our office would ask for a reset of those hearings on Easter Sunday to move them into the week, the regular work week, so that we could attend the bond hearings during the regular work week and not tie up all of the additional resources that would be needed on Easter Sunday, to allow staff to spend time with their families and to allow the court to have a much smaller docket on Easter Sunday so the court can continue their regular proceedings on Easter Sunday, be able to get out early. The court in their text message to me indicated that it would be a very long day on Easter Sunday having all of these bond hearings. The judge replied back acknowledging my text message and saying that they would, instead of having a dual docket, which he had talked about in his text message to me, there would be a single docket and they would just call the cases in order and allowing us to have our motion to continue on each case. I was very surprised on Sunday when Judge Acosta asked my assistant district attorney if we had the cases in our office. That is completely irrelevant to whether or not we are ready to proceed on a bond hearing. We are not ready to go to trial on these cases because we don't have the cases in our office. But that is irrelevant to being prepared for a bond hearing. We were prepared for the bond hearings. We had run rap sheets on all of the 200 plus individuals. We had the complaint affidavit, and we were prepared to go forward on the bond hearings. As per my instructions to my assistant district attorney, we asked for a continuance so that the staff and the other people related to the cases did not have to work on Easter Sunday. The judge summarily denied all of the motions to continue in one motion, in one hearing. He said, I'm denying all motions to continue, and I'm going to grant a personal reconnaissance bond to each of them, finding that the state was not ready to proceed. We categorically deny that the state was not ready to proceed. We were ready to proceed. We were very much ready to proceed on each and every one of those hearings. I was very surprised to hear the judge's ruling. We had intended for the same proceeding to happen on Monday. Again, Cesar Chavez Day, another county holiday. We were going to ask that those hearings be reset to be heard later in the regular work week. Due to the judge's ruling, we announced ready and did not ask for a continuance because we had been informed by another magistrate that the same thing was going to happen. They were going to deny our request for a continuance, which I might add again, we are entitled to under the law. It is not discretionary, we are entitled to under the law. On Monday, we asked that the hearings all be on the record. Another thing we are entitled to under the law. That motion was denied. The defense asked to waive, they waived the hearing, the bond hearings, because they recognize that with a PR bond, the defendants are released from jail. They are most likely going to be picked up by Border Patrol and will most likely be deported. The defense then does not have the opportunity to consult and collaborate with their clients in properly defending their cases. On all of the cases where the defendants are released on PR bond, the state will still be proceeding with prosecution, which means that we will be seeking we will be filing the cases, we'll be seeking a hearing in court. The defendant will most likely not show up, so this will result in a warrant for the defendant's arrest. If the defendant comes back into Texas, into El Paso, they'll be arrested on the warrant. It's a unfortunate situation, simply made more unfortunate by the judge's ruling. Now, hopefully have summarized the situation as what has happened. I'll be glad to take questions.
What conversations have you had with the Public Defender's Office? I know they've raised a bunch of concerns about this.
The only discussion I had was initially after the judge's first ruling. I informed the public defender that it was still our intention to proceed with the moving for a continuance, although we had been told that that was probably going to be denied. It was after that conversation when I read the judge's statements saying that we were not prepared, which is just categorically untrue. Due to that change in circumstances, we changed our strategy. I know that the public defender believes the cases are defensible. That's fine. That's certainly their position, and we'll have to address that once we get further down in the court process. I want to emphasize that the public defender has not seen anything other than the complaint affidavit, nor have we. We don't have the cases yet in our office. All we have seen are the complaint affidavits.
Yesterday, the public defender chose to waive 37 bond hearings for the migrants rather than to turn them over to federal custody for the federal charge. What is your response to that? Do you think it's a good idea for them to keep these migrants in state custody?
I certainly understand why the public defender would want to do that. The first hearings that were had on Sunday, all of those migrants would have been released to Border Patrol, and then from Border Patrol, Border Patrol will do what they do, which is to process them for deportation, which takes those immigrants, those migrants, away from the public defender's ability to consult with their client. So the public defender is now left with a prosecutor coming into court and saying, we're going to prosecute these cases, and a public defender standing up and saying, I have no way to defend it because I haven't talked to my client. I don't know what my client's position is on this case. And it makes it a very difficult position for a criminal defense attorney to be left kind of holding the bag without having consulted with their client and not having seen the evidence against their client. They really can't consult with their client. So I certainly understand why they would do what they did. If the state's able to obtain convictions on these cases, it will hurt that migrant's ability to apply for asylum. It will hurt that migrant's ability to come back in the country at a later date and apply for further immigration status. So as a criminal defense attorney, they would certainly want to be in a position to better defend their client by having that ability to have communication. I certainly understand why they would move to waive the hearing in order to have the opportunity to at least have that conversation with their client. You know, is this something you want to risk, or is this something you want to just, not risk at all and just be deported and know that there's a warrant coming up? Just having that longer conversation is something that I would certainly understand why the public defender would want to do.
Is it in the best interest of the Paso community, the DA's office, and the use of resources to charge these people instead of just turning them over to federal law enforcement?
Well, that's a good question, and until we actually see the cases and we look at them, it's not one that I can fully answer. I can tell you this. While I'm not particularly concerned about immigration cases, I am concerned about violence and destruction of property. And that group moved forward in a way that caused violence to the National Guardsmen. The National Guardsmen were punched in the face. The knees of Guardsmen were stomped on. That could obviously result in very serious permanent injuries. someone tried to take a gun away from one of the National Guardsmen. Obviously, we don't have to talk about how dangerous that is, right? So the violence that was perpetrated on the National Guardsmen is extremely concerning to me. The property damage, the stomping of the concertina wire, the knocking down of the fencing, that kind of violence done to government property, and then the storming of the gate, 425 people storming the gate. I'm not convinced that 425 people are going to storm the gate, get through that gate, and then just surrender and stop if DPS and Border Patrol hadn't been there to stop them. I'm not convinced that they were going to do that. They had already indicated their propensity for violence, their propensity to tear down and destroy property. And if we don't send a message that they can't do that, I'm concerned. I know that after this happened, there was another group of 250, followed by a group of 200, followed by another group of 100 that had to be repelled from Gate 36. We have a group of close to 1,000 that has left Chihuahua City that is making its way to El Paso with instructions to go to Gate 36. I'm concerned that if we don't send that message that you can't come to Gate 36 or any place in El Paso and perpetrate violence to get into the United States, that we can stop them. And if they think that they can come in, that the migrants can perpetrate violence, can destroy property to get into the United States, what's going to stop them from coming across Paisano and going into our neighborhoods? And if they're willing to tear down government property, what's going to stop them from tearing down people's backyards, going through people's backyards? If they're willing to assault government officials, what stops them from assaulting our friends, our neighbors, our mothers and fathers in those neighborhoods? We have to send the message that you cannot do that we have to be a community of law and order. I mean, even in the words of former Congressman Sylvester Reyes, we have to hold the line for the safety of our community. And I think that that's what we're doing whenever we address people who are showing a propensity for violence and criminal destruction when they're being that way. It's not just an immigration issue. It's an issue of people showing a propensity for violence and destruction. Again, we'll have to review those cases, and we'll look at them on a case-by-case basis. And I don't know that we're going to prosecute every one of them. I don't know. We're going to have to look at the cases on a case-by-case basis. But I do know that we've got to send the message that violence and destruction of property is not going to be tolerated.
So leading up to the incident, the border riot, I mean, is it your opinion that Texas DPS troopers were blocking the migrants from legally seeking asylum and sort of creating the conditions where they needed or thought they needed to push through? Like, could they have just allowed the migrants to go and surrender to Border Patrol and not have the wiring up and cause the whole incident? So
there's not. The reason why they're going to Gate 36 is because Border Patrol routinely uses Gate 36 as a funnel for people to go through. They aren't preventing small groups coming through. It's whenever you have a group of 1,000 people that is going to overwhelm the system that they really are blocking everything. And whenever 400 people are trying to push through, that's when they're holding that line. So I don't think that it's really a matter of, and it wasn't troopers, it was National Guardsmen. That it wasn't a matter of troopers stopping people from being able to seek asylum. It's a matter of saying, you can't come through and overwhelm the system. You can't push through in a mob type mentality.
In the past, there have been large groups of migrants forming at the gates before. I mean, what makes this situation different for the troopers to have that kind of mentality over getting in front of the federal agents?
Well, again, it wasn't troopers; it was National Guardsmen, and it was. I don't know the circumstances or what was going through their mind, but I know that the group of 1,000 people that had gathered was causing alarm, and with 400 people that were actually pushing through and were in a riotous type of atmosphere, a mob type atmosphere, that type of mentality is not a calm, hey, we're here to surrender. It's a much more violent atmosphere. And that type of violent atmosphere, we've got to send the message, can't be tolerated. You know, if you're going to do this, you have to do it in a much more calm way and according to the laws.
What is your confidence level in terms of when probable cause arguments are had in some of these cases? What is your confidence level of how these cases will hold up once there are probable cause arguments had in court?
Well, okay, probable cause was established whenever the warrants were signed. So on all of the cases where someone was booked into jail, there had been probable cause found. Some of them were found by magistrates, by justice of the peace outside of the jail magistrate. Some of them were found by the jail magistrates themselves. So the jail magistrates who had later come on to grant PR bond had actually already found probable cause for the detention. So my confidence level was 100% because they had already found probable cause in signing the warrants. What we have to find is proof beyond a reasonable doubt to gain a conviction. And I don't know. I'll tell you that the cases involving the instigators, from what I have seen of those cases, and again, we don't have the complete case, from what I've seen of those cases and the videos that I've seen, I feel very confident that we're going to reach beyond reasonable doubt on those instigators that we've indicted for felony offenses.
You were saying that, of course, these violent events are concerning for the community. You need to prosecute them, but also you were mentioning before about the county jails. And the sheriff's office were saying yesterday that, of course, both the annex and the one right next to us, they're at capacity. What are your thoughts, or what do you think is the solution to prevent from happening? The jails at capacity, move them to other places, like you said. Some of them were transferred to Houston. What are your thoughts? Yeah.
The county jail right now does not have the ability to move people to Houston. That was the Border Patrol that had moved some people to Houston because the Border Patrol facility didn't have the ability to hold enough people here. We are currently working. I've met with the governor's office and with officials from the Texas Commission on Jail Standards to find a solution to that problem. We haven't managed to reach resolution yet, but we are working towards finding a solution to our current El Paso County jail crowding issues. So we're working on a solution and hope to have one soon.
Do you think, we had 200 and plus charged with just the misdemeanor charges. Do you feel that DPS maybe kind of picked everybody who came through at that time into this bucket of participating in a riot? Do you think that may be overreach on their part, and then kind of now you're having to deal with the after effects of it?
I don't know. Like I said, we haven't seen the whole case. I can tell you that under the law, everybody that participates in that group, if you don't disengage from the group, you are guilty of the behavior of the group. So if that group is moving forward and you understand that what that group is doing, and that group is moving forward, even though you're on, say, in the middle of the group, and you don't actually trample the wire yourself, but you see what the group is doing, you are guilty of the group behavior. That's the way the riot law works. So it's a justified arrest. Now, whether or not we decide to go ahead and charge everyone within that, we're going to have to see. That's a case-by-case analysis. But the arrest is justified. It's a probable cause standard, and it's certainly a justifiable arrest because that's the way the law works. Now, whether we decide to prosecute, that's something we're going to have to look at. I will tell you that we're going to, when we get those cases, we're going to look towards prosecuting each and every one of the cases, regardless of the fact that they may have a PR bond.
Can we talk real quick about staffing for your office, trying to review all of these cases? Obviously, that's 200, and we're dealing with other DPS arrests for the migrant smuggling. Is your office prepared to be able to review every single one of the cases that's coming in right now on all of these charges?
Sure. We, as one of the larger offices, particularly on the border, we have the capability of doing that. We do also have the Border Prosecution Unit, BPU, which is the coalition of prosecutors all along the border, have volunteered to assist with additional prosecution resources if needed.
So this isn't going to affect your caseload and your normal cases that get filed every day?
No, I don't think that. We will not sacrifice prosecution of victim-related crimes in El Paso just to address these crimes.
Where do you think the miscommunication was between the judge and your office on you guys being ready to handle those cases?
I don't know.
Any suspicions?
Oh, I have lots of suspicions, but none that I can really go into or would choose to go into.
Is there concern that we're going to, as SB4, if it becomes a law, we're going to see more of these incidents on the border?
Well, the intricacies with prosecuting an SB4 or Chapter 51 case, there's a lot of intricacies there. I would say that everyone who had come across in that 425 would be subject to a Chapter 51 prosecution. In the charging decision, let's say DPS had arrested all of them for riot plus a Chapter 51 violation. As a prosecution decision, we may choose to prosecute under the easiest one to prosecute under and under the more tried and true law versus a new and constitutionally questionable law. So while it's potentially a Chapter 51 violation and a prosecutorial decision making, we would probably choose to prosecute under riot versus Chapter 51 because riot's it's been on the books since the 1970s and it's a very solid law versus Chapter 51, which certainly has constitutional challenges. And there's also different intricacies involved with Chapter 51 that make it a little bit more difficult to prosecute.
And then the people who were released on bond or on PR bond, the chances of you guys finding them aren't very good, or what's your hope for those?
Let's say if on a case-by-case analysis we decide to file on all of them or most of them or whatever, we would go through the process. There's a lengthy process involved to actually get a warrant issued for their failure to show up to court. Then it's a matter of whether or not they actually show up at some point down the road. And if they show up in El Paso County down the road, they would be picked up on that warrant and would be brought into jail, and then we'd start the actual court process at that point.
So as far as you're aware, they've just been taken back to Border Patrol, right? Or
I have been told that they had detainers on them. I have not verified that, so I can't verify for you that they were detained. But I was told that Border Patrol had a detainer on all of them, so all of them would have fallen into Border Patrol custody and then actually been deported. When they came into DPS custody, they had finished the deportation process with Border Patrol and were ready to be deported. And then that's when they fell into DPS custody, and now so they should actually have been very quickly deported. But I can't verify that for you.
and there's been no conversation with BP about holding them in ICE detention or there's some other facility?
They would,
There's been
for pretrial detention on state charges, we can't cross over to federal custody or federal detention facilities because wherever they are housed, it has to be in a facility which has been licensed by the Texas Commission on Jail Standards. So if we house them in FCI Latuna, for example, FCI Latuna would first have to agree to house pretrial Texas inmates, and then the Texas Commission on Jail Standards would have to go out there and certify them, which is a process whenever you have a federal agency agreeing to meet Texas state standards and, federal agencies. So that's a little more difficult than getting the Texas Commission on Jail Standards to certify, for example, West Texas, which is a private facility, would be easier to say, okay, to get to get you up to Texas Commission on Jail Standards, you have to do A, B, and C, which is a private company. It would be much easier for them to make those changes.
Okay, thank you.
That's all the time we have, folks.
Appreciate
Cut
it.
short, sorry.
Can I ask one more question? Is there any concern for any possible civil rights violations on these folks if they get deported and aren't able to defend themselves in court?
That would not be a civil rights violation, no. It would be because the criminal charges had not been adjudicated. So they were arrested under a probable cause warrant, which had been signed. So there's not a civil rights violation there. The warrant being issued for their failure to appear in court, they were able to be picked up at a later date to defend that warrant. They're still not prosecuted. They
Even
don't
if
have a
they're not in the
conviction.
country to be able to defend themselves?
Well,
If they're deported?
right. They would be able to. They're not convicted of the offense. They just are being picked up on the warrant to come into court at that point.
All right. Thank you, everyone.
Thank you.